generous and very kind introduction. I got worried there for a while. Well, welcome to the law school, Ambassador Osowski, Ambassador Farumbi. I would like to especially acknowledge the presence of the members of the Human Rights Claims Board, because we were all together in the campaign to ratify the Rome Statute. And I can tell the ambassadors here present that it was actually a 10-year campaign which involved a sea change in attitudes. When I think Dr. Parong and I were together as co-chairs of the coalition, when we made the first, it was the Cabinet Cluster on National Security, which first heard the presentation on the Rome Statute, and that was in the year 2001 or 2002. We just had a new government then, Gloria Macapagal Arroyo, and we were welcomed into the presidential palace, and as soon as I entered, I already got the message. The room was full of men in uniform. It was basically the AFP, Armed Forces, and the Philippine National Police who were there. And I still remember that the reaction to my presentation. They used the Tagalog expression, parang kumuha ng bato na pamalo sa sariling ulo. It's like getting a rock with which to hit your own head. And that was their attitude. And they gave me, they had all sorts of examples. They said, look at that false report from the Mindanao operations. If we have a court already at that time, by today, we would be already sued before the ICC. And we saw the change over 10 years. And in that campaign, our partnership with the Global Coalition of Civil Society and with the international community was the most important element in helping convince the Philippine government that signing this treaty is actually a good thing for the Philippines. So we began with so in the beginning it was only the Department of Foreign Affairs which was in favor of ratification. And then before long we were able to win over the Department of Justice. Because in terms of judicial cooperation, most of the questions came from our prosecutors and from our Justice Ministry. And then after that, we gained the support of the Department of National Defense. And the way I will explain this is that the coalition was able to bring in to the Philippines their counterparts from abroad. So that it's not as if it is the local activists telling the government that this is good. It is their counterparts, fellow military officers, fellow lawyers, fellow prosecutors, fellow judges, telling them that this is an independent court. It imposes individual criminal responsibility, not state responsibility. It depoliticizes the entire process, and that it has been helpful to many jurisdictions, even for their own national prosecutions. The last holdout, actually, I was surprised with this turn of events, was the Department of the Interior and Local Government. In fact, even when the department agreed, it was the Philippine National Police which had the last-ditch effort to oppose the treaty. I testified before the Senate during the ratification, and even on the day of the voting, the Philippine National Police still had its own objections on record. That's why if one looks at that decade-long campaign, it was actually the fulfillment of a long process, not just of promoting the Rome Statute as an official campaign with the Philippine government. That is, getting the President to sign it, getting the President to send it to the Senate for ratification, and getting the Senate to ratify. It was a long process legally and politically. Professor Roque, in fact, filed a case with the Supreme Court to compel the President to forward the signed treaty to the Senate. President Arroyo did not want to do that. That is the case entitled Pimentel, Eta Rosales, Roque et al. versus Executive Secretary. But not just a bureaucratic and legal process. It was also a process of developing roots locally. And that is what the ICC, that is a process that the ICC's work will continue in the Philippines. Now, let me turn to the process itself. There were, for the benefit of the ambassadors here present, there were 3 nominees: the Bangladesh former Chief Justice, a law professor and law dean from Jordan, and the Philippine nominee. Myself, the Bangladesh former Chief Justice, has withdrawn. There are only 2 candidates left. The 2 candidates were asked by it's called the Advisory Committee on Judicial Nominations. The Philippine equivalent is the Judicial and Bar Council. Called the 2 nominees for a face-to-face interview at The Hague. It was a closed-door interview. I appeared before that interview. And after that, there was a panel, a public presentation by the 2 candidates, sponsored by civil society, by the Coalition for the International Criminal Court, the CICC, and together with the diplomatic corps at The Hague. The official report of the Advisory Committee is now out, is posted in their website, and in all candor, I am so relieved to hear from our ambassador that the recommendations were most favorable for my candidacy. Let me now close by focusing on some issues that were raised either in the public forum with civil societies or with in the formal interviews before the Advisory Committee of the ICC, which included a former judge of the ICJ, Bruno Sima, from Germany. One thing raised in the CICC Coalition Forum was the reservation by the African member states. And Ambassador Farundi would be familiar with I would say, in fact, I will use a stronger word. It was a grievance that the ICC was created to deal with war crimes, crimes against humanity, genocide all over the world. And yet, today, more than 10 years after its creation, if one looks at the roster of defendants, of cases, they are all in Africa. And there is therefore a rising concern about the geographical imbalance. It is a fact. It is a legitimate concern. I confronted it during the public forum when I was asked about issues facing the ICC. The basic principle is that it is not enough that the court be just. It must also be seen to be just. And the legitimacy of a court is first and foremost secured by fair and just proceedings, the conduct of the trial itself. But however professional, however proper the trial is, if the larger context is under a cloud about the geographical imbalance, that professional handling of cases by the court will be overwhelmed by that concern. But we must also look at the context. A court is a passive institution. It can decide only a case that is filed before it. So it is a burden less on the court itself, but on the prosecutor. But it is not as if civil society is completely helpless, because there are so many of these violations being committed all over the world, and the Rome Statute was drafted in such a way that the prosecutor's motu proprio powers, the power of the prosecutor herself, in fact, the prosecutor is an African woman, to receive reports from civil society, to entertain those reports, and to conduct investigations on her own, is a power that was designed precisely to deal with problems of this nature. And since it is a problem at the level of perception, Therefore, when civil society raises those issues, they must be given full attention, not just by the ICC in its website, but also by civil society and hopefully by the media, so that the impression of a geographical focus can be overcome. Also, member states can take it upon themselves for self-referral. And indeed, it is, even if we take it as an issue of geographical focus on Africa, majority of those cases were by self-referral, by African states referring their own cases to the International Criminal Court. The second issue that I addressed is something for which I think a Filipino lawyer actually has some advantages. It is the recurring debate within the court between judges from civil law traditions and judges from common law traditions, each with their own practices, with their own standards. And when I was apprised of this issue, I felt, hey, that's not a problem which is unusual for Filipinos. The Philippines actually has a hybrid system. We were a colony of Spain for 350 years, a colony of the US formally for 50 years. And so our constitutional law is entirely American in origin. A problem which was faced by the moot court team that we sent to Oxford. Because if they keep on citing American cases on what the Americans call the First Amendment, these are strange citations for an essentially European set of judges. But we confront it in the Philippines every day. And my favorite example is our rules of evidence are American in character, derived from the federal rules on evidence. But they were designed for jury trials. In the Philippines, we don't have any jury. That was a deliberate decision taken by the Americans when they arrived here, when they established the civilian government in 1903.